All right, so the next issue is sentencing, and they start discussing sentencing in the context of um, capital cases. In times past, I'd say within the last 50 years, I don't know exactly when it changed, a jury in non capital cases would recommend a sentence um, as, along with their verdict. That certainly has changed. Um, and almost nobody that's practicing law now remembers when that was the way it worked. Um, but anyway, the juries still do the sentencing in capital cases. Um, the um, modern death penalty, as it's often called, um, is what transpired as a result of the case of Furman versus Georgia in 1972 that effectively abolished the death penalty um, everywhere, and um, because there was so much arbitrariness in capital sentencing. In other words, a, a person could get sentenced to the death penalty for um, reasons that were not discernible and comparable crimes often had um, different sentences. You know, some would get death, some would get life. Uh, Seemingly very serious, heinous cases would um, get a life um, without parole, typically sentence, whereas a routine, if that's the right word, a routine, um, armed robbery gone bad would result in a death sentence with no element of torture or suffering or whatever. Um, so, um, as the book tells us, Justice Potter Stewart said that getting a death sentence was akin to being struck by lightning. There was just no way to predict, except perhaps race um, of the victim, race of the perpetrator, um, would often play a role. For instance, um, the if the victim's white and the perpetrator is black, um, there's a very great probability that they would get the death penalty, and that has been borne out way past this Furman v. Georgia case. Anyway, what happened was that the court said there had to be some kind of way to narrow the cases that would subject someone to the death penalty, some way to narrow um, the kinds of cases that would get a death sentence. And Georgia rewrote their capital sentencing statute, um, and it began this process of aggravating factors being alleged and proven, and um, those are limited to specific kinds of cases and attributes of the homicide that have to be proven um, by the state. And then there are mitigating factors that the defense would introduce that would be basically anything about a person's life history, military service, employment, good record, lack of criminal history, um, or challenges in their life like a terrible abusive childhood, some mental illness that didn't rise to the level of an acquittal for not guilty by reason of mental disease or defect, but nonetheless affected the crime. Um, a um, any number of you know mental developmental delays, things that don't avail you of a mental state defense, but nonetheless could mitigate your moral responsibility for the killing. Those mitigating factors were also made a part of the sentencing statute. And then the way that aggravating factors are weighed against mitigating factors, um, that is a defined process. And so this guided deliberation that was built into the new Georgia death penalty statute, it was reviewed by Gregg versus Georgia, and the the death penalty was back on again. And at that point, states began to just basically copy what Georgia had done with their statute. So the death penalty um, persists to this day. States, a lot of states um, either never had a death penalty or abolished the death penalty, um, and that's going on to this day. Colorado abolished their death penalty very, very recently, mainly because very few people were given death sentences, and the operation of death row for 3 or 4 people, I believe, um, was just deemed to be kind of pointless. And then, um, so they just abolished their death penalty. Now, the death penalty has been limited by findings or by holdings in 2 cases within the last 20 years. Atkins v. Virginia was the case that said that people who have a developmental disability, at the time called mental retardation, now referred to as an intellectual disability, that persons who meet that threshold of however it is that a state decides to define mental retardation, is not subject to being sentenced to death. Now, the the Supreme Court did not come up with a hard and fast rule of what mental retardation means for all 50 states, but they left that to the states to figure out what it was, and they have done so, and the Supreme Court has continued to check unreasonable applications or failure to apply scientific understandings to defining mental retardation in states, the most recently in Texas. But generally, if you have an IQ below 70, 70 or below, you are deemed to not be subjected, not eligible. It's an odd choice of words, but that's the way it's phrased. You're not eligible for the death penalty. Then, some couple of years later, Roper v. Simmons, what is a case that said that people who commit capital offenses at an age of under the age of 18 are not subject to the death penalty. So if you are below the age of 18 at the time of the commission of the crime, the death penalty cannot be imposed. Previously, it could be imposed on children as young as 14 years old at the time of their offense. So that was a tremendous advance, I believe, in our criminal jurisprudence and in staking out that as contrary to the way civilized people should operate a criminal justice system. And what the decision was based on um, was basically science that um, people are developmentally not complete uh, at age 18, uh, and 18 was a just a cutoff. They had to have a cutoff, and that's what they decided. Um, it's not the age of majority in Alabama. 19 is, and it while the recognition of developmental um, lack of total complete development as the reasoning for this exemption to the death penalty didn't carry out to the point where we consider particularly males to be developmentally done, so to speak. Um, that doesn't happen until the early 20s, it's believed. Um, and so that immaturity um, doesn't magically cut off at 18, but that's when the law cuts off this exemption to the death penalty. Um, but it is both with respect to the Atkins v. Virginia case and mental retardation and the juvenile death penalty. Um, all of this was based on uh, new scientific norms and understandings that um, basically science caught up with the law or vice versa. Um, so um, there's another development that is noted in this sidebar. The Miller versus Alabama um, case was a further innovation in death penalty jurisprudence. Well, not death penalty, capital cases, and um, that case held that a juvenile could not be subjected to an automatic life without parole sentence because that's what Roper v. Simmons did was said you can't execute someone who committed a crime under the age of 18, a capital offense, so they just get life without parole. Miller v. Alabama is a case that said you can't automatically give um, a juvenile life without parole. They, for the same reason the death penalty is not appropriate, neither is that. And so there, after Miller v. Alabama, there was a procedure put in place, essentially like the sentencing phase of a capital case, where you try to uh, persuade the judge, not the jury in this case, but the judge, that the death penalty, or sorry, that life without parole should not be given, and that the person get a life sentence or some term of years that approximates a life sentence. Um, so, Miller v. Alabama, no automatic life without parole for juveniles. There has to be some hearing where some particular Miller factors are considered and weighed by the judge. That case originated in Lawrence County, Alabama. I know a number of the lawyers who were involved in that case at the trial level, and it's interesting that Evan Miller, who is the Miller in that case, um, his resentencing is still pending, even after the reversal in 2012. They had his hearing a few years ago, and the judge is still considering it. Um, um, and there, I guess, is no rush because there just wouldn't be sufficient time for a life sentence to play out in this category, in this circumstance where at least 15 years would have to be served before he was ever parole eligible. And the idea that a person would make parole in their first time is not realistic, and so that the slow pace of Miller v. Alabama, that the actual case being brought back to Lawrence County Circuit Court, the fact that that's taking some time, time is, I suppose, on the side of the defendant here. All right, so let's talk about, just in a little bit more detail, capital sentencing, the death penalty sentencing. In Alabama, there used to be, the current law is that in order to get a death sentence, there had to be 10 or greater jurors to believe and vote in favor of a death sentence. Unlike in Alabama, again, we're unique now. We're an outlier. Once again, there is no requirement of unanimity in that sentencing decision. So 10 to 2 is a life recommendation, 11 to 1, 12 to 0 for death is a death recommendation. And then anything less than that will require a life sentence to be imposed. That's the law now. As little as 3 years ago, just a little bit more than 3 years ago, we still had the jury override, and that was that a jury could recommend life without parole or death, and the judge could override that recommendation. But, as you might suspect, being elected, the overrides were overwhelmingly the overriding of a life recommendation for a death sentence. And so the judicial override was really a pretty rotten practice. Rare that did it save lives, but it cost people their life, the ability of the judge to override the judgment of even a 12 to nothing life recommendation. And then there were the spikes in death penalty overrides or life recommendation overrides in favor of the death penalty in election years. In those even-numbered years in the fall, a judge in a close race would impose a death sentence for political purposes, and certainly people who've run for higher office have not bucked the death penalty system. Bill Clinton, when he was running for president in '92, famously allowed a man with pretty severe mental retardation to be executed. A guy named Ricky Rector, R-E-C-T-O-R, in Arkansas, when he was running and as governor of Arkansas had the power to stay or commute that sentence. But he didn't. Stakes would have been too high. The public sentiment on the death penalty was more favorable back then, favorable to the death penalty than it is today. And so he made a political calculation. Well, so do judges when they're when the spotlight is on them. So the abolition of the override was long overdue. Now, the lack of unanimity is the next challenge, and in light of this Louisiana v. Ramos case, that may be closer to happening than we think. Alabama has a sorry history about the death penalty. It's a racial history, a history of no one granting clemency, except in a rare instance in 1998, I believe. people just love the death penalty. It does something for them. I can't account for it. Um, and prosecutors love it. Even if they don't really believe in the death penalty themselves, they made a deal with the devil, I guess you would say, and they use it for leverage in getting cases settled. Um, but in any event, um, that covers capital sentencing. Um, um, I want to go back and say that this Evans v. or rather, I'm sorry, Miller v. Alabama case is a Brian Stevenson victory. If you have read or in tune with um, Just Mercy or the McMillan case or the Hinton case, um, this is another one of Brian Stevenson's big triumphs is Miller v. Alabama. All right. So if we are dealing with sentencing that is non-capital, often um, what happens is there are guidelines, sentencing guidelines in the United States federal courts. I believe our federal guidelines were first adopted in the mid '80s as a means of standardizing federal sentencing. So, in Alabama, you've got um, 67 counties, not that many judicial circuits, but um, just think about the United States, as broad a country as it is, top to bottom, east to west, um, with the judicial circuits, with the divisions within a state. Alabama has three: the Northern District, Middle, and Southern District federal courts, a number of judges in each of those federal districts. But there was a lot of disparity in sentencing. So the federal sentencing guidelines tamped down on that, and there's some copycat state sentencing guidelines in various jurisdictions. Alabama has a sentencing guidelines for drug offenses, property crimes, and some what are called personal crimes like robberies and involving danger to the person, some assaults. And those are criminal history driven, and the more serious the crime, the more numerical points are given, and then a variety of other factors go into determining a sentence range that a judge is obliged to either follow or make occasional and rare departures from the guidelines with justification for doing that in the sentencing order. In the federal courts, it's a slightly more complex process, but the outcome, in fact, in the federal sentencing guidelines, was just longer sentences. In Alabama, the opposite has happened, that the guidelines have attempted to drive the incarceration rate down, and it did to some degree. But due to some political pressures, I think that the momentum is likely headed the other way due to some high-profile crimes um, that were committed by people on bond and on probation and on parole. Just circumstances that are going to cause a backlash, have already caused a backlash. But in any event, that's generally what drives sentencing or sentencing guidelines. A person's sentence is often based on what's called a pre-sentence report that looks into criminal history and just less elaborate than a capital case, but certainly, characteristics like employment and military history, military service, things like that, that either point to a person as a good person or point to them as a person who is deserving of greater punishment than a person with a lesser record. Um, so that's what the pre-sentence report is. It is also a representation of the facts of the case. That's a very important part of a pre-sentence report because that's the thing that the people at the Department of Corrections see and say, oh, this crime happened like this. And if there are inaccuracies in that pre-sentence report, they have to be corrected because it may affect a person's eligibility for programs in the prison. Like, for instance, if there's an element of violence put in the pre-sentence report that wasn't proven at the trial, you don't want that information going in the pre-sentence report and causing a person to be ineligible for work release or educational opportunities in the DOC. All right. So what happens in non-capital sentencing is a person gets either a term of years and they're sent to prison for X number of years, or a person can be granted probation, which is you're not in jail, but you're subject to monitoring and scrutiny and supervision. And your sentence that you're given is suspended. That is, you're not serving that sentence. You're on probation, and at the end of your probationary period, if you complete it successfully, then this sentence that's hanging over your head goes away. If, on the other hand, during your probation you mess that up, you commit a new crime or something that violates the terms of your probation, you quit reporting, you quit paying your fines, restitution, and so on. What happens there is your probation can be revoked, either to serve some period of time as a warning, or your entire probation can be revoked and you have to go serve your sentence. So that's generally the way that sentencing works out. You either get probation or you get a term of years in prison. Now, how that time is counted and how they count off good time and all that are other matters within the DOC. So rarely do you serve the entirety of a sentence that you receive because of good time and other factors. That's not necessarily true in the federal system. They have what generally is called truth in sentencing. That is, you serve the time that you're given. There's no such thing as federal parole anymore. You don't make parole anymore in the federal system. Perhaps you serve less time, but the time that you're given, you serve generally day for day with some exceptions. Very narrow, very limited exceptions. But anyway, that's the way the federal system works. Now, in the state system, there's a sentence generally is you serve about a third of it, unless it's a Class A felony or greater than 15 years. Otherwise, what is called good time or correctional incentive time can operate to reduce the time that you actually do serve. Okay, so that I think covers everything I wanted you to know about sentencing.